I want to welcome our guest for this hour to talk about this, National Trial Attorney Michael Jaafar. All right, so let's talk, if we could, Michael, about the fact that this is the second trial for first-degree murder, and the first one we know was deadlocked after only 4 hours, which is not that long to declare a mistrial, but that's what happened. How does that affect the state, the prosecution, in retrying this case, in your opinion?
In my experience and in my opinion, this always usually benefits the state because they can see the mistakes they made in the first trial. They can see what mattered to the jury. They now know exactly perhaps why they were deadlocked, and they have a do-over. They have a mulligan. And so this benefits the state. And the states usually get it right the second time. The famous trial of the former governor of Illinois, Rod Blagojevich, deadlock in the first trial, and they convicted him quickly in the second trial. So, I mean, this benefits the state. And, you know, I mean, they're placing him at the scene, and they have basically somebody who can testify directly to what happened. So I think this definitely benefits the state.
And I think it's the most compelling witness that we want to hear from. Jennifer Spohn, again, that's the mistress of the husband, the babysitter for the family, and she's on the stand. The sidebar is over. Let's go back into court. Another sidebar still with us, Michael Jaafar and Corey Pegues. Michael, this witness's credibility really makes the difference for this jury, because we know the defendant says she did it. She's explained, she's testified that he did it, that he told her he shot his wife not once but twice. How do you think she's doing in terms of her delivery, demeanor, and credibility?
I think she's doing an A+ job on all fronts. Her credibility's through the roof. She has nothing to gain by testifying against him. The defense is going to claim, obviously, that she has immunity, but why would immunity make you want to make up a story that you covered up a murder with a former lover? I mean, it's not like they're paying her, and it's not like they're getting her out of jail. There's some witnesses where what they're offered is, we're going to shorten your 20-year sentence to a 2-year sentence. That's something tangible, but she's being offered immunity. And if she doesn't testify, there's really no case, right? So she's creating a case, and clear, I need to tell you what happened. And the prosecutors are doing a good job is painting him as a villain.
And Corey, what do you think in terms of her credibility and her saying, listen, it was getting heavy, I couldn't keep carrying this. This is why I'm telling this story. Corey, we can't hear you. There we are. I think we could hear you now. Nope, still can't hear you. All right, let's see if we're able. Darn it, we're not able to hear him. So Corey, hold those thoughts. Let's go back into the courtroom.
Let's bring in our guest, still joining us for this hour, trial attorney Michael Jaafar. Michael, great to see you. Thank you so much again for being on the program with us. Got to get your take on Jennifer Spohn, her testimony. You know, she's the last witness. You got to take your witnesses where you find them, Michael. We both know that. She wasn't the strongest witness, but she's basically the star witness.
Yeah, not every prosecutor has the benefit of having a videotape showing exactly what happened, and they just point to the videotape and say, look at what happened. They have to rely on witnesses. They have to rely on testimony. A lot of the witnesses are unsavory. They're not reliable. They're not dependable. And especially when you have a case like this that's decades old, it becomes even more difficult. I'm with you. I saw the cross-examination of the defense attorney. He did an awesome job, especially when he was talking about her financial hardship, and she's behind on the mortgage. She was pregnant with a kid where the father was in jail, and she was supporting her sister and her mom, whereas the defendant, Mr. Malark, was financially stable, was giving her money. I could see how, and we know where he's going to jump to in his case. I could see how he's going to jump to, well, perhaps you killed her because you wanted to have him all to yourself, and you wanted to have his financial stability, and that is what you were missing. Perhaps you killed her. Perhaps you know, pulled the trigger. I could see how he would jump to that, and how that would insert doubt for the jury.
Yeah, no question about it. The one thing I wrote on my paper, you know, whether you believed her or not, what I thought he did a great job on cross-examination bringing out was that she was desperate. And desperate people do desperate things. And I think that's the thing that jumped out at me about her testimony.
Yeah, I think that's true, and that's what he did on cross. But is it enough? And here's why I asked this of you, because Michael and I were talking about, okay, the last jury was a hung jury, a mistrial, we know that. And so you have to believe at the heart of the case, you can't decide if he did it or if she did it. So where do you make that point? I thought that cross-examination was pretty subtle about that. Do you think they can come out in closing argument and say, hey, by the way, you heard from her own mouth that she could not have made it financially without him?
Absolutely. When you're defending a client who's accused of murder, you can only say either he wasn't there or somebody else did it, and you have to give a plausible explanation to who else would have done it. Well, this poor woman went out to buy milk and she was murdered at the Winn-Dixie, right? That's very fishy. So, you can only, it has to be someone that knew her who killed her, because they didn't rob her. She wasn't wearing jewelry. They didn't take cash from her. So somebody who knew her killed her. It can only be somebody close to her or somebody who had a motive to kill her. So they are doing basically the only thing they can do, which is kind of a Hail Mary, which is, she did it instead of my client. So I do believe that this is the only shot they have. What other shot do they have, right? This would be it.
And it was effective last time, but you're right, there's two people, and we don't know which one did it. Do you think, Michael, the defense was strong enough?
Yeah, I don't think you have to say that she did it. I don't think you have to prove she did it. You're just trying to have a viable alternative theory to show that there's problems in the state's case, and guess what? He's not the only one who could have did this. As a matter of fact, he's probably not the best candidate who could have did this. She makes a much better murderer in this case. I don't have to prove she did it or say she did it, but she certainly had the motive, right? And she certainly was desperate enough. So, jury, you got to take that into account when you go in and look at this evidence, which is kind of sketchy to begin with.
And there's the closing argument.
There
if they're watching, you've just summed it up, because I think that's what they have to make sure they say to this jury during closing.
Yeah, absolutely. And Michael, when you start looking at a case like this, that is absolutely the way you approach it. There's these little bits and pieces of evidence that you have to start knocking down, and then you have to present, as you said, this viable alternative. And I think that puts you in a good position.
Yeah, you want the jury to go into the jury box with one overwhelming feeling, and that's doubt. That's what you want them to go in there with. And so that defense attorney, I think he was a little bit aggressive because the woman was a little bit, cordial. She was demure, like Judge Ashley said, but he was very aggressive. He was a bulldog. We see that on TV, but actually that doesn't play well to a jury. But the way he approached it was awesome. His questions about the financial situation were awesome. They gave me doubt. So yeah, you want that jury to go in there with the overwhelming feeling of doubt.
Yeah, absolutely. All right, Michael, you're going to stay with us. Let's bring in Michael Jaafar. And Michael, we did during that hear about mental anguish. He's kind of highlighting this is what I'm going to have you testify. Is that appropriate? Is that a good thing to do?
I think so. I mean, you want that testimony from the family members. At the end of the day, I'm kind of stubborn on the foreseeability issue, but once you overcome, if they overcome the foreseeability issue, I think this testimony could be helpful. I don't really think it's going to be too persuasive, but I think it can't hurt. He's a brother. He was 10 years old when his sister went away for 87 days. So, I think it just ratchets up the emotions for the jury.
Yeah, no question. I mean, they were asking, as you mentioned the other day, for $200 million. So they've got to bring home to this jury exactly what he was suffering, the mental anguish and the loss that he felt as a 10-year-old boy. So I think it's real important for this jury to hear. All right, Michael, stand by. We're going to take a break.